lawsuit against Charlotte Latin School can proceed. So the state Supreme Court made the ruling last week overturning a lower court decision that dismissed the case. The lawsuit filed by two parents in 2022 accuses the school of introducing politically charged discussions of race and gender into its curriculum. So the parents claim that they presented their concerns to officials before the school expelled their children. The school has now argued that it was within its rights to expel the students based on its contract with parents. Chief Legal Analyst Clive Rhodes joining us now to be able to talk about this case. Charlotte Latin, a private school here in the Charlotte area. Now the Supreme Court is allowing parts of this lawsuit to move forward. Khalif, walk us through this.
Incidents happened in 2020, obviously in the wake of George Floyd. School starts implementing discussions on race, discussions on politics, discussions on gender. This lawsuit's filed in 2022. A number of things happened at that point. They filed a lawsuit. Lawsuit is dismissed in the lower court. They take it to the Court of Appeals. Court of Appeals upholds that decision. These folks file a lawsuit in the Supreme Court, asking the Supreme Court to overturn the lower court's decision. Supreme Court said, listen, the lower court got it wrong. The reason why you dismiss a case for most of the time is because plaintiffs have failed to state a claim where relief can be sought. And that's what the lower court said, that there was a number of things in this complaint that seemed like press clippings, that seemed like, 60 pages of allegation. And this is what the court said, that occasionally resembled a press release. And because it resembled a press release, there's no standard way that a complaint needs to be submitted, but there needs to be an actual allegation of some type of wrongdoing. And so if you're not even alleging wrongdoing, then no relief can be sought. The Supreme Court said, well, even if it wasn't in the manner in which we would like it to be, they did find a narrow set of facts that properly state a claim. And because there's a state of claim for breach of contract, for fraud, for unfair and deceptive trade practices, this claim can go forward because of those things. But the lower court didn't find that. So now in this case, we'll have to go back and they'll have to at least evaluate those claims.
So just kind of take us back, because the emotion of where we were in this country when George Floyd died and how the reaction from that came. And then you have students here on a high school level processing all this information. And then these kids get kicked out of school. I mean, what really stands out to you?
Oh, it's a couple of things. First of all, there's these types of things that were happening during 2020. There was a social awakening, a consciousness of folks wanting to understand what was happening, not just in their own backyards, but across the country and across the world. And there were folks that were trying to find ways to implement these things into real world learning examples. And so you had a number of schools within the public school system, within the private school system, that tried to find ways to take these real world examples and give it a learning lesson to students. And so I can say incidents like this prompted a lot of lawsuits. We're a litigious society. Folks sue all the time. I just think in this case, specifically the private school setting, the facts are on the school side for removing the children from their school for a number of reasons. It's not about the social unrest. It's not about the curriculum. It's a contract. When you sign an enrollment agreement, when you sign a parent-student partnership, that's a contract, and the courts have held that consistently, that if you breach that contract, if the school feels like you can't uphold your end of the bargain on that contract, the school will be within their right to terminate. I mean, there are multiple cases right here in North Carolina, 2018 case. This case in North Carolina, specifically why the lower court held that it shouldn't be upheld, is because of the term case from 2022. I think those are multiple examples of where the courts have held in our own state that private schools have the ability to do that. Schools out other places around the country have ruled the exact same way.
How do you think this is going to play out?
I think when it ultimately goes to the lower court, they'll look at these examples of breach of contract. That there's no support for a breach of contract claim if the school has determined they violated this enrollment agreement. The fraud, I think that's going to be a fact dependent. That unfair and deceptive trade practices, that's where you can potentially get treble damages, 3 times what you're attempting to say they have claimed you for. And so I think when you go through that, all fact dependent, but that contract or breach of contract, the law is going to be on the side of the school.
College Rhodes, appreciate it. Thank you so much for that.
Queen City News Plus. Just search Queen City News on your smart TV's app store.